Mr. Chairman. I was very happy to see Acting Controller Sue announce the OCC was revising the ill-advised Trump-era Community Reinvestment Act rule. After last week's OCC announcement, I hope to see a joint interagency CRA rulemaking by all three bank regulators. This is an important civil rights law that should not be enforced in a piecemeal fashion. So, Vice Chair Qualls, have conversations begun among the agencies on how the Federal Reserve, the FDIC, and the OCC might align their regulatory efforts around the CRA?
We have, throughout the CRA process, as you know, it's been the Fed's position and desire that we would end the process with a joint rulemaking. We've each shared the comments we have received on our separate processes, the OCC's rule, our advance notice of proposed rulemaking. We're all aware of the input that has come from that, and it remains our objective to see a joint rule.
Mm-hmm. I appreciate that it's your objective. The question is, since there is a change at the OCC, I understand what you did before. The question is, are you engaged now in an effort with the OCC to align yourselves?
Well, we're certainly talking with them, and obviously the position of the OCC has changed, and therefore our continuing engagement will, I think, is likely to result in the objective we've always had. But we do continue to talk with them. Absolutely.
Well, let me reiterate how critical it is for all three banking regulators to get to the same page when it comes to the CRA. It's especially important having seen the disproportionate impact this pandemic has had on minority-owned businesses and communities. I have a sense that some of my colleagues would think that none of you have any role to play in terms of dealing with the great inequities in our society. I totally disagree with that. And certainly when you have oversight over the Community Reinvestment Act, this is a key tool to try to deal with some of the issues that we face today, for which the CRA was originally created. So I hope you all get together, adopt a unified rule that strengthens the original intent of the CRA, which has never mattered more. Let me ask you, this month marks 10 years since the deadline for finalizing the incentive-based compensation rulemaking, the rule to ban practices that reward senior bank executives for irresponsible risk-taking. In those 10 years, we experienced the London whale, the Wells Fargo fake account scandal, and most recently, Credit Suisse involvement with Archegos capital management. All three instances of corporate malfeasance or mismanagement were tied to executive pay incentives in one way or another. So was the Federal Reserve forced to take some regulatory action to the London whale and the Wells Fargo fake account scandal?
I guess two things I'd say. Well, the London whale was before my time, and I'm recused from the details of Wells. So those specific questions I'm not sure that I can answer, but I can certainly say that
it's a simple question. It's not something that you have to recuse yourself. It's an acknowledgement of what the Reserve did, whether you were involved in it or not. My understanding is that there were regulatory actions. And so if there were, you take my word for the moment because my time is limited, wouldn't it be more effective oversight to help prevent these types of scandals from taking place in the first place?
We do, in our supervisory engagement with the firms, that is an important element of it. Their compensation arrangements, their incentive compensation practices. As you know, the incentive compensation rule is a joint agency rule that requires complicated joint agency negotiation, but the Fed does closely supervise compensation practices.
10 years, 10 years. I don't care how complicated the matter is. Doesn't take 10 years for great minds to get together and think about what is an appropriate way to deal with excessive compensation. I think preventing scandals and resultant consumer harm is more effective. The Federal Reserve, along with other regulators, have a tool in their arsenal to help curb this type of risky and irresponsible behavior. And yet, after 10 years, the incentive-based compensation rule remains unfinished. That's unacceptable. And I will be pressing each of the regulators to come before us. It's about time to get this done.